I have 9:30 on the dot. I call the Texas Commission on Law Enforcement Commission meeting to order. It's Thursday, December the 5th. The meeting is being held at the Texas Commission on Law Enforcement headquarters, located on the second floor at 6330 East Highway 290 here in Austin. The door is open for public access, and I do know that we have, for the record, that we do have signage out front for those folks that want to come in. Show them the direction over here to the commission meeting. A couple of things before we get started. This meeting is being held by a video conference call. For all participants, please remember that while speaking, your face must be clearly visible and your voice audible. Commission members, please remember to keep your video and audio on during the meeting and identify yourself by name before speaking. And with that, Melissa, if you would do the roll call.
Commissioner Kim Lamo.
Present.
Commissioner Jason Hester.
Here.
Commissioner Justin West.
Here.
Commissioner Patricia Burris.
Here.
Commissioner Jana Atkins.
Here.
Commissioner Michael Griffiths.
Here.
Commissioner Justin Berry.
Here.
Commissioner Connor Harvey. Commissioner Connor Harvey.
Hey, Connor, can you hear us? I guess not.
He's muted.
I'll go ahead and go to the next one and we'll come back to it.
Commissioner Sergio Sines.
Present.
You have a quorum.
Okay, so before we move on, we'll see if we can get Commissioner Harvey's audio taken care of. Can you message him on the? Okay. We get Mike Griffiths. Did she get Mike? Did you get Commissioner Griffiths?
Yes.
Excuse me. Does someone have his number to call him? I don't think we need. Oh, there you go. Connor, I think we have you now. Can you hear us?
Yes, sorry, I think my audio setting, my computer was on, but not it wasn't coming through Teams for some reason, but I'm good now.
Very good. So we will officially mark you present.
Oh, thank you. I didn't realize it had started. Thank you. Yes, present.
Okay. Moving on to agenda item number 3, I will now turn it over to the presiding officer, Kim Lamo, for some comments.
Well, good morning, everyone. Thank you to all of you that are joining us online. Thank you to my fellow commissioners and also to the staff who worked hard to make this meeting possible. I hope all of you had a great Thanksgiving holiday this past week. As many of you can remember, the commissioners reserved this date in the event that we felt it was necessary to hold a meeting before our next regularly scheduled meeting in March of 2025. Recently, staff presented a dilemma related to the enrollment of several law enforcement heroes into the Texas Peace Officer Memorial. Unfortunately, we have a significant number of these heroes to consider, and the Memorial Committee would not have been able to process all of the enrollees in time for next year's ceremony if we had waited to vote on this at the March meeting. So there was no hesitation in setting this meeting, as we owe the families, friends, and departments of those heroes the ability to honor their fallen loved ones at the next ceremony and without delay. So thank you very much for taking the time to meet today so that we can take care of this business. I also wanted to send my condolences to my colleague, Mike Griffiths, on the loss of his, he has a deputy who lost 3 of her children last week in a tragic accident. So Mike, our condolences to you and her and to her family and to your entire agency. I can't even imagine as a mom and as a parent, I can't even imagine. So I also want to thank my colleague, Jason. As we set up this meeting, the staff had made the offer to go ahead and everyone drive up here to Arlington and have the meeting here in Arlington. That just did not seem like a prudent use of state resources or their time. So we made the decision to have the meeting there in Austin. And in lieu of me driving or spending 6 to 8 hours on the road today, Assistant Presiding Officer Jason Hester volunteered or agreed to sit in and gavel in the meeting today. So Jason, I'm very appreciative to you for doing that and saving additional state resources. And since you are there with staff and with general counsel and, are able to, fully experience and see guests and visitors and such, would like to ask you to go ahead and conduct the meeting if you are willing to do so, sir.
Absolutely.
Okay, I think that would be easiest and best since you are there. So I will turn it back over to you, sir.
All right. Moving on to agenda item number 4 is to take action to enroll and induct officers in the Texas Peace Officers Memorial Monument. Director Grigsby.
Good morning, Commissioners. As the presiding officer said, these are the names that will be moving forward for induction at the ceremony at the end of April for the Peace Officers Memorial Monument. And so we will go ahead and read them into the record. They are Officer Alexander Arango, Everman Police Department, end of watch October 22nd, 2020. Sergeant Ricky Eade Jr., Texas Tech University Police Department, end of watch December 9th, 2020. Correctional Officer Harold Paul Skip Smith Sr., Texas Department of Criminal Justice, December 15th, 2020. Corporal Juvencio Garcia Jr., Rio Grande City CISD Police Department, January 15th, 2021. Sergeant Jed Shelton, Beaumont ISD Police Department, August 24th, 2021. Sergeant James Demmett, Friendswood Police Department, December 27th, 2021. Director of Field Operations, Beverly Matthews Good, U.S. Department of Homeland Security, Customs and Border Protection, January 28th, 2021. Investigator Eddie B. Hutchison III, Walker County Criminal District Attorney's Office, February 10th, 2021. Corrections Officer Tracy Annette Adams, Texas Department of Criminal Justice, March 6th, 2021. Sergeant Clay Garrison, Port of Galveston Police Department, August 25th, 2021. Senior Sergeant Steve Urias, Austin Police Department, August 26th, 2021. Officer Gregory Randall Young, Vernon College Police Department, September 1st, 2021. Sheriff Robert Inclán, Gonzales County Sheriff's Office, September 5th, 2021. Sergeant Shad Eugene Hammond, Texas Department of Criminal Justice, September 13th, 2021. Corrections Officer Jose Angel Hernandez, Texas Department of Criminal Justice, September 13th, 2021. Park Police Officer Jay Pena, San Antonio Police Department, September 26th, 2021. Officer Randy Stollard, Central Independent School District Police Department, November 2nd, 2021. Officer Wayne Butch Noel Jr., Meridian Police Department, December 29th, 2021. Sergeant Gerardo Morales, El Paso Police Department, January 7th, 2022. Investigator Steve Carnes, Palm Green County District Attorney's Office, November 13th, 2022. Deputy Ronald Bates, Harris County Sheriff's Office, February 10th, 2024. Deputy Sheriff Charles Rivette, Montgomery County Sheriff's Office, February 21st, 2024. Border Patrol Agent Christopher Luna, U.S. Department of Homeland Security, Customs and Border Protection, March 8th, 2024. Investigator John Hampton Cadieux III, Harris County Sheriff's Office, April 23rd, 2024. Officer Kyle Hicks, Corpus Christi Police Department, April 24th, 2024. Senior Police Officer Vicente Ortiz Jr., Corpus Christi Police Department, June 1st, 2024. Detective Fernando Esqueda, Harris County Sheriff's Office, July 11th, 2024. Sergeant Billy Randolph, Fort Worth Police Department, August 12th, 2024. Officer Darren Burks, Dallas Police Department, August 29th, 2024. Trooper Kevin Alexis Ramirez Vasquez, Texas Department of Public Safety, September 28th, 2024. Deputy Constable Ruben Garcia, Cameron County Constable's Office, Precinct 1, September 30th, 2024. And Deputy Sheriff Lex Allen Love, Wise County Sheriff's Office, October 2nd, 2024. I will say with that, unfortunately, sadly, there are going to be more names that will be added, but as our rules require, the names are to be posted on the agenda of a regular commission meeting, and a couple of those happened after the deadline for that. One other thing I will point out is there are 32 names that we are presenting today. You'll notice about 20 of those were from years prior to this year as we continue to work through the ERS approval of primarily COVID deaths. And so we do expect and certainly hope that the numbers will continue to decrease for future ceremonies. But certainly these individuals deserve to be recognized, and I appreciate you being here to do so.
Thank you. Commissioners, any questions for Gretchen or staff?
No, but I would like to make a motion to enroll and induct the officers as read into the record in the Texas Peace Officers Memorial Monument.
Second.
Okay, I have a motion by Commissioner Burris and a second by Commissioner Berry to enroll and induct the officers read into the Texas Peace Officer Memorial Monument. Any further discussion? We will do a roll call vote since we are all online. And if you would, Melissa?
Commissioner Kim Lamo,
Yes.
Commissioner Jason Hester,
Yes.
Commissioner Justin West,
Yes.
Commissioner Patricia Burris,
Yes, aye.
Commissioner Jana Atkins,
Yes.
Commissioner Michael Griffiths,
Yes.
Commissioner Justin Berry,
Yes.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines.
Yes.
Motion passed unanimously.
Thank you. Moving on to agenda item number 5, discuss and take action on proposed amendment to existing TCOLE Rule 217.7 related to obtaining fingerprints for all appointments. General Counsel Beecham.
Good morning, Mr. Chair, Madam Chair, Commissioners. This morning for your consideration is proposed amendment to existing TCOLE Rule 217.7. In force, what this rule does is require a subjective criminal background check before a person is appointed by a law enforcement agency. The agenda today was a perfect opportunity to present this proposed amendment to supplement the suite of rules which you recall that were proposed at the McAllen meeting. This proposed amendment was a result of both some discussion during the meeting and also discussions outside of that meeting. We'll present it this morning for your consideration and executive staff comment here in a moment. I will lay this rule out for you. As it is, again, this is a proposed amendment. This is the first reading. Again, this is brought to you on this commission meeting agenda in order for it to be brought for a final vote in March with the other rules that were proposed in McAllen, and it will be subject to public comment between now and then. The proposed amendment to 217.7, you will note it essentially moves the substantive paragraph or subsection, I should say, to obtain new proof that a person has been fingerprinted. It's subjected to a criminal history check. This is prior to the 180 days since a last appointment language where it existed before. And now functionally what it does is before a law enforcement agency can appoint that person who's seeking a license as a peace officer, that fingerprint and criminal history must be done. For your consideration for proposed amendment to 217.7, subject to any comment or other additional information from executive staff.
So I just want to make sure, and probably for the other commissioners to make sure that we have a good understanding. There is a chance of a number of law enforcement applicants that have been around for a while that are not enrolled in RATBAC that we're trying to get caught up in. But this is one way that if an officer moves from one agency to the next, that no matter what, they're getting a new set of prints that's always going to be reran through the system, and that the new agency will be subscribed to as well as TCOLE, to make sure that if there's anything that's happened in between those appointments, that's another fail-safe for staff to be able to get notified of those. And so TJ, am I off base? Or
no, I think you accomplished three big things. One is if they've never been subscribed, we now have the opportunity to subscribe, because we do have people that first became police officers before that process. The second one, the big one we see is that when agencies rely on name-based criminal histories, that there can be errors there. They cannot find records. Fingerprint-based criminal histories eliminate that error. And so if we are not going to require unappointed licensees to report their arrest, we want to ensure that when they seek their next appointment that we catch that. And the best way to do that is through fingerprint-based criminal histories rather than name-based. They're already required to do it. This just takes that. If they're in the 180-day window, they now have to do prints.
Okay. Commissioners, any questions? If not, I will entertain a motion to post agenda item number 5 for Rule 217.7 into the Texas Register.
So moved.
Second.
All right, I have a motion by Commissioner Burris and a second by Commissioner Berry to post the amendment to existing Rule 217.7 to the Texas Register. Is there any further discussion?
I believe that second was Sheriff Griffiths.
Was that Griffiths?
No.
Nope.
It was Barry.
I thought I had it right. Come on, Justin. All right. Ms. Moore, a roll call vote, please.
Commissioner Kim Lamo,
Yes.
Commissioner Jason Hester,
Aye.
Commissioner Justin West,
Yes.
Commissioner Patricia Burris,
Aye.
Commissioner Jana Atkins,
Aye.
Commissioner Michael Griffiths,
Aye.
Commissioner Justin Berry,
Aye.
Commissioner Connor Harvey,
Yes.
Commissioner Sergio Sines,
Yes.
motion passed unanimously.
All right, motion passes unanimously. Thank you. Moving on to agenda item number 6, discuss and take action on the proposal for decision regarding the peace officer license of Michael D. Hambrick. And I will turn it over to Assistant General Counsel, Mr. Heath.
Thank you. Good morning. This is a proposal for decision for Michael D. Hambrick. Respondent was convicted or placed on community supervision for indecent assault, a Class A misdemeanor. And the executive director determined that this was an offense above a Class C misdemeanor and filed a license action seeking a 10-year suspension. Respondent then requested a SOA hearing. The administrative law judge issued a proposal for decision finding that respondent committed an offense above a Class C misdemeanor and recommending the suspension of respondent's peace officer license for 10 years. And I will highlight some of the findings and analysis of the ALJ. Specifically, crimes against children are more serious offenses within the crimes against person, which are more serious than crimes against property. Respondent's conduct evidences poor judgment and decision-making, breach of trust, and disrespect for the rules. Law enforcement officers are held to a higher standard of conduct and a level of professionalism than civilians and are expected to uphold and protect the law and not victimize someone who is in a vulnerable position. And respondent did the opposite during the incident. Respondent's conduct undermined the important ethical and professional standards for law enforcement, which are important to public safety. Respondent's misdemeanor offense involves intimidation and manipulation, which might be considered a coercion since respondent took advantage of the situation. When an adult victimizes a child, there is some level of control or coercion. The ALJ agrees with TCOLE that the mitigating factors in this case do not outweigh the severity of respondent's misconduct. And the ALJ finds that because the level of aggravating factors in this case, the 10-year suspension of respondent's license is proportionate and justified. The executive director recommends acceptance of the PFD and a 10-year suspension of respondent's peace officer license. This proposal for decision is for your consideration.
Thank you, Mr. Heath. Commissioners, any questions of General Counsel? Hearing none, I'll entertain a motion at the pleasure of the commission.
Make a motion that we accept proposed suspension of Mr. Hammock.
Second.
All right, I have a motion by Commissioner Berry to accept the proposal for decision for Mr. Michael D. Hambrick, and a second by Commissioner Harvey. Any additional discussion? Hearing none. Ms. Moore, roll call. Oh, stand by.
Do you got me, Jason?
Yeah, go ahead.
Okay. So after reviewing not only the PFD, but the supplemental information that we received in our packet, this offense to me is one of the most egregious that I've seen. I cannot in good conscience vote to only suspend the license of Mr. Hambrick. I think that an argument can be made under TAC 37 Rule 223.19 that we can indeed revoke the license of Mr. Hambrick. Let me pull up this section. So, clearly we're going with the portion of the rule that fits the misdemeanor offense, and so he is potentially subject to up to no less than 120 days and up to the 10 years of a suspension. But I believe that based on the offense itself, an argument can be made under Section B that that rule states the license of a person convicted or placed on community supervision for an offense directly related to the duties and responsibilities of any related offense held by that person may be revoked. Typically, when we've seen this section used, it's for things like official oppression or tampering with a governmental record. In those instances, those are also misdemeanors, although official oppression, we know, can range from a first-degree felony all the way down to a Class C misdemeanor, depending on the amounts involved there. I think looking at the 4 prongs that are required that the commission consider, including 1, the nature and seriousness of the crime. Obviously, this is a very serious offense. This is a crime against children. So it's clearly a crime against persons, and more so it's a crime against vulnerable victims here. And the second is the relationship of the crime to the purpose for requiring a license for such office. I think kind of, looking at Major Vineyard's testimony in that SOA hearing, he really clearly states out the coercion involved. The more I read about what the other victim stated, what the victim herself stated, the mother of the main victim, I mean, there's clearly grooming going on here. You all who are in law enforcement in particular know what that looks like. We talked a lot about it when I was a prosecutor and in trials, educating the public what that looks like, and that it's a long process. That was clearly done here. Here's a person who's received, all the trust of not only the public, but this mother and of this teenager. And, he clearly violated that mother's trust in watching over her child. When the child was asked after the fact if this was something she would have consented to had she not been in and out of consciousness and inebriated, she said no, she would not have consented to this. The crime, like I said, involves trust, a violation of that public trust, the public safety, and I think, like I said, that's sufficient for that second prong. The third is the extent to which a license might offer an opportunity to engage in further criminal activity of the same type as that in which the person previously had been involved. Again, being a law enforcement officer gives you immense public trust. You are endowed with protecting the public's safety, protecting vulnerable victims. And again, here, I mean, individuals are going to give Mr. Hambrick their trust by virtue of his position. And if this is what he's doing when he thinks people, aren't really watching him, I can't imagine what else he's willing to do. And again, this is a grooming type offense. This is something it wasn't a one-time thing that he said or did. It's something that's a culmination. And that fourth prong says the relationship of the crime to the ability, capacity, or fitness required to perform the duties and discharge the responsibilities of such office. Again, there's a clear violation of trust. There's coercion that we see in all these prongs. We certainly see the coercion and violation of public trust, a mother's trust, the victim's trust. And should he keep his license, he has the ability, obviously the capacity, to do this again to other people, to other vulnerable victims out there. You all know when you're out in the field that most people you see are not in their right mind a lot of times. They're suffering through their worst days a lot of times when you've come in contact with them. And we ask our law enforcement to be empathetic, to serve, to not ever take that for granted or misuse that trust. And I don't have the confidence that Mr. Hambrick won't violate that trust and coerce other people based on everything I read in the packet. So I think this is the dispositive section, dealing with this license revocation. I think, the question is whether this is the type of criminal offense that falls within the set of crimes determined to be like directly related, as it states there in section B, to the duties and responsibilities. Again, I think if official oppression and tampering with a governmental record fit within that section, then surely this offense of assault in this way can fit as well.
Okay.
I want to.
Mr. Beecham, Mr. Beecham, before we, who else said something? Somebody say something.
Yeah, it's Barry. I kind of wanted to echo Commissioner Burris's points as well. I know I made some phone calls yesterday about this case as well. I very much felt the same way. So I very much look forward to Mr. Beecham's thoughts on this. And then my follow-up question is has this officer taken the required course of interdiction for the protection of children? We take this class because it is our duty. It's part of our training and part of our requirements of our profession to care for children at all times. You're never truly really off duty. And if that's part of your training, to always be on the lookout of ways how to protect children, and he's violating that, I kind of wonder, I kind of agree with Commissioner Burris. Is there grounds for an argument to say he kind of did violate his office and his official duties to protect the children that he's received training for?
Thank you, Justin. Mr. Beacom, if you would you lay out the options and things for consideration for the commissioners, please?
Be glad to. Thank you, sir. Commissioners, I think it'd be a good time to talk about and review what your discretion is in any administrative case, particularly those when you get a proposal for decision in front of you. As we talk about in commissioner training, the administrative law handbook, when it relates to determining a sanction for a proposal for decision, commissioners have wide discretion in doing so. However, that discretion is not absolute and it is not without some limitations. And I give you a relevant analogy that we've talked about in the past, both from commissioners and staff, is you will hear that the commissioners are like an appellate court when they read proposal for a decision. I think that is a generally correct analogy. However, I think with some important and relevant caveats for us today. Again, as an appellate court, there are different standards of review, meaning sometimes you get to look at the whole record. Sometimes you get to start from scratch. Sometimes you have narrowly tailored issues before you that you can only consider in that narrow scope of both the evidence and the law. Now, I say all that to give you an idea of what your discretion is. Again, let's go back to when you have findings of fact, this is under the Administrative Procedure Act, unless there is a clearly erroneous or wrong, a misnomer, some untrue statement of the facts, which that's not what we've talked about here today. The findings of fact you're bound by, which you have those. I think there's 20 or 30 some odd findings of fact in this case. But again, what you do have discretion in is determining that ultimate sanction. Now, you heard Commissioner Burris walk through the revocation rule earlier. And also, I think it's important to note that, as she stated in the past, the revocation rule, particularly as it relates to those 4 factors, has been, for the most part, almost exclusively certainly at least to the best of my memory and what I've been able to see over the years, has been official oppression, theft by a public servant, offenses which as an element of the offense require the person committing the offense to be in a position of authority and or in our case, hold a peace officer license. So as a matter of law, if you officially oppress someone, if you are a public servant and you get a disposition for theft by a public servant, you automatically fall into this directly related categories. Now, again, you have the ultimate discretion in determining a sanction in this case. What you're going to have to think about is, in this case, which revocation was not pled, I think that's an important consideration as far as notice issues go, is moving forward, determining and giving guidance to staff the scope of 223.19, the revocation standard. Do you want staff to go beyond official oppression cases? Do you want staff to go beyond theft by a public servant cases? Do you want to potentially encompass, because the argument can be made for every misdemeanor offense in the penal code would meet these specific 4 requirements. Obviously, some are going to get a lot closer to what the current standard is than others. A DWI, one could make the case that it falls under these revocation standard, but it would be certainly not as compelling as an official oppression case, or even more towards the other side, the case we're discussing today. So I say all that to, number one, you do have the ultimate discretion in determining sanction. That is not absolute. You are bound by the facts of this case, and you are bound by notice provisions and proper application of the law. And number two, if you do decide to go in this direction for offenses that are outside, misdemeanor offenses that are outside official oppression and or theft of a public servant, we will take that guidance and certainly move in that direction. Any questions about the discussion we just had about the scope of your discretion?
John, this is Kim Lamo. I've got a question for you. Is there anything that requires that we give notice to Mr. Hambrick? And is there any obligation for us to solicit or consider any response?
Thank you, Madam Chair. That's a good question. Normally during the course, let's take our normal case with a proposal for decision where the sanction would be let's say we requested a 10-year suspension for a DWI case or a 5-year suspension at SOA. We get the proposal for decision and it comes back something less than, let's just use for our purpose of conversation, a 1-year suspension, we get it back. The executive director would then file exceptions with the administrative law judge, sending a copy to the respondent. Now, that's not a requirement that you do so in order to entertain a different sanction ultimately, but it certainly puts the respondent upon notice that there may be something other than what was sought at the hearing. In our current case, since we pled 10 years, we requested 10 years, and we got 10 years in a proposal for decision, which looking back, I went back on this as well. I'm hard pressed to find where we received a 10-year suspension in many, if any, cases over the past 10 years or so for any type of misdemeanor suspension. In this case, we got exactly what it was we asked for. As a result, no exceptions were filed. So in that respect, respondent had no notice really up until now that revocation was on the table.
Can I add to that?
Sure.
So I'd like to add to that because I did testify in this case, and that's what they have is I explained that my division's job is to be the fact finders, and I don't recommend punishment. However, I sit in on the meetings when it's presented to the executive director, and then I sit in on the meetings with the commissioners, and that I believe that I understand what their expectations are, and I can represent those. And so the PFD summarized what I talked about, but what I said was pretty much all the things that Commissioner Burris said. And I said that it's my belief that these rules were constructed for particular situations, and that what they're looking for is when there's that element of care, custody, or control, and you violate that we are not going to trust you to be in a position of public trust where you will have that over innocent people. That's what I talked about. And I use the family violence exclusion as an example. Even if it's a Class C family violence, because you violated that care, custody, control within your family, we're not going to trust you to be a peace officer. But I also said that I don't believe that this particular situation falls in those rules. That is the expectation, but that I believe that we're limited to 10 years. And although I think the commissioners would expect a revocation, that we're limited to 10 years by rule, and that's why that's the appropriate punishment. So that was my testimony. That's what he heard, and that's what his attorney heard during the course of that hearing.
I got a couple of thoughts, and I don't know if it can be applied in this manner or not, but it sounds like we may, at least I got the feeling that this rule may need to be updated to reflect some of today's standards and expectations of our officers, especially when it comes to crimes against children and crimes that are sexual in nature. I definitely think we need to have a relook at this, because like I said, I know TJ, you and I talked yesterday, and John, we talked yesterday, and like I said, I was quite disgusted when I read this, and that he has the ability to hold his license. I mean, hopefully no other agency will ever hire this guy again, but the fact remains, if he has the ability to get his license after 10 years, that's, I'm sorry, that is absolutely disgusting to me. And for him to have the audacity to say that he only needed it reduced down to 2 years is even more, just more disgusting. Like I said, I share probably the same concerns every commissioner on here, and especially Patricia Burris. Like, it's hard to be in good conscience knowing that we're capped at 10 years with this guy. And the last thing I want to do is give him an avenue that allows him to find a gray area and use as a loophole to get his license back if we go a different route. And so I personally want to see this revocation rule get updated to reflect our current standards when it comes to crimes against children and crimes that are sexual in nature.
I also kind of to piggyback on what Justin said, looking at it just long term, again, if we got the 10-year suspension, 10 years, he could come back into this job. And this is kind of a side note on some of our, maybe changing some of the rules up, not only what Justin Berry mentioned, but I have cadets, or I have people who want to apply for my academy that have a Class A misdemeanor that is a community supervision, et cetera, and they can't apply, period. They have to ask for a Class A waiver and then come before us for that. And if I understand correctly, from my discussions, that this guy, 10 years goes by, he can come back and request to come back to work. And if he complies with his license during that 10 years, getting his training, et cetera, he could actually just go right back and go back to work. He doesn't have to have a Class A waiver through us again. And again, like Justin said, I don't know the agency would hire him, but that's another thing that I'm looking at, that we're barring some folks to come in here, but then we have people that get in trouble that are already in this job, already doing this job. They get in trouble, they get a Class A, and they could come back once they get their suspension done. And so that's another thing we may look at in the future as far as a rule change for that.
Yeah. So is his license active now?
His license is active now. He's been unappointed since the day of his arrest. So they separated him the day of his arrest. And Commissioner Atkins, I'll tell you the same thing that I told Commissioner Berry. I encourage you to consider the totality of the circumstances, that I think we've drastically improved the requirements of background investigators, the appointment process, our ability to see things from the enforcement division and from the commission division, and that you have built a system of rules and put people in place and checks and balances, that we have safeguards so that if one rule doesn't hold up, we have other options. And I think all of those improvements together make it far less likely that he could be appointed 10 years from now. The practices that you have put in place are in addition to your ability to provide sanctions on this particular case. So there are other safety nets besides a revocation.
So we have a motion and a second on the table to accept the PFD. In conversation that I'm hearing from the commissioners, there seems to be some agreement to ask staff to go back and relook at this particular part of the rule and bring forth recommendations back to the commissioners for some updates to this. Commissioners, do I have that pretty well right of what y'all are pretty well asking for this?
Yes.
Okay.
Yes,
And
yes.
I have a question to go along. Could we kick this can down the road to look at the rule first and then come back and revisit this decision?
No, not as a matter of procedure. It would be the rules in effect in the time of the PFD, I believe.
Okay.
And I would want to remind you that everything on this agenda was put on this agenda because it is time sensitive.
Yeah. Any other comments from commissioners?
Is there an
Yeah,
option that we can come back to at the next meeting and consider revocation?
I do not believe so, Sheriff. I don't know, Counselor.
I mean, there's nothing materially that would change rule wise or otherwise. I mean, you're kind of bound to the facts and the laws as they exist right now. I mean, you can certainly table it if you want to, but again, this was brought for a specific purpose on this commission meeting.
Counselor, this is Kim Lamo. Question. Could we add a caveat that TCOLE would not reinstate the license unless he came before the commission, whoever the commissioners are at that point in time? Are we able to add that into it?
I don't think.
I would be hesitant to do that, Chief Lamo, for a variety of reasons. One, I think that's out. I think you can, let me back up. Much like at the El Paso meeting, the question came up, can we impose conditions of probation? Yes, you can. However, this is not a probation case. We are adding additional reinstatement requirements which do not exist in the rules now. I would be hesitant to do that versus if we were just doing conditions of probation. Now, I'm thinking aloud here, and I've not looked at the probation rule on this in a minute, but if you wanted to, you being the collective commissioners, you could extend. Perhaps, again, I would need to look at the probation rule. To achieve what you're talking about, one option would be 10-year suspension, hypothetically speaking, plus X amount of probation, and as a condition of that probation, come back to the commissioners for reinstatement. I don't necessarily know if that allays the fears that I have or the concerns that I have with adding additional reinstatement requirements which don't exist in the regulations.
And I think I go back, for me personally, I think the changes that we've made, the legislative changes that have made, that when the time comes for this person to be reappointed to an agency, I think the background investigation things are going to come into play here for agency executives. And I also do believe, that'll all get taken care of. Again, I'll restate, everything on this agenda has a reason to be on the agenda. And so with that, Is there any more comments from the commissioners as we have a motion and a second pending on the table?
I just want to put out there that I'm not going to be bullied into making a decision today, considering how strongly I feel about this case. If there's something else to be looked at, like our general counsel is mentioning, then we need to be sure we have every possible remedy, that we're aware of every possible remedy. And I want to be 100% certain. It doesn't sound like there's 100% certainty today. I'm getting a feeling from the commission that no one feels very happy about feeling, in a sense, like we are rubber stamping the decision that came from SOA. But I just wanted to share that's where I am right now on this.
Commissioner Hester, I got a question.
Yes, sir.
Commission. In addition to requesting with that rule change, is there a way we could also look at creating a new rule that in the event any applicant or licensee has ever had a license expenditure for a crime against a child or a crime sexual in nature, that they cannot have their license reinstated? Is there a way we can look at a rule for that for down the road?
I think there could be a charge to staff to take a look at the options to bring back to the commission for what would ultimately be the eligibility standards that the legislature has delegated to the commission for offenses that are not felony offenses. We do have that authority within statute as a commission. And so I do believe that that could be a direction to staff to look at to bring back to the commission at a future time. Again, I will say, I personally, I disagree with Commissioner Burris in this. I don't feel that there is a bully here. I think we have the findings of fact before us, and a recommendation by the executive director to accept the PFD. I think TJ put it very succinctly as well on his testimony and how that has been considered up to this point. And that if the commission wants to make a change in that direction moving forward, then we should do that moving forward. I don't think this would personally I think it would be a problem if there was some kind of appeal, if we wanted to do something other than what's laid out on the table before us. Just my opinion. That is not of legal background. With that, is there any other comments?
I want to make one more. I agree what you're saying. TJ did lay out that he brought forward the same argument that Commissioner Burris is making now to SOA. And based on the findings of SOA, their consideration of the current laws and rules that we have in place, that we're kind of hamstrung to make a decision today. But per Commissioner Berry's point, if we have staff bring back a new rule for us to implement, that is a way to prevent this individual from being reappointed in the future. So we can still come back and make the effect we have without running the risk of an appeal to a district court judge and keep this gentleman from being relicensed within the next 10 years.
And I think the general consensus is that at all types of crimes that are especially against vulnerable populations and children in sexual nature such as this, not just to the limits of the official oppression and the things that have been talked about before. So. With that, we have a motion and a second. Any other discussion from commissioners before I call a roll call vote?
Could someone restate the motion, please?
The motion was to accept the proposal for decision for a 10-year suspension for Michael Hambrick. That was made by Commissioner Berry and seconded by Commissioner Harvey.
That's correct. Yeah, that's correct.
All right. With that, Melissa, roll call vote, please.
Commissioner Kim Lemo.
Aye.
Commissioner Jason Hester.
Aye.
Commissioner Justin West.
Say again, Justin.
Aye.
Thank you.
Commissioner Patricia Burris,
Nay.
Commissioner Jana Atkins,
Aye.
Commissioner Michael Griffiths,
Aye.
Commissioner Justin Berry,
Aye.
Commissioner Connor Harvey,
Aye.
Commissioner Sergio Sines.
Yes.
Motion has passed with 8 yeas and 1 nay.
7-1.
I mean, 7, sorry.
All right. With 7-1, the motion passes.
It was 8.
Sorry.
Is it 8?
Oh, yes, it is 8.
Oh, yeah, I'm sorry. 8. I wasn't counting my name on the list. My apologies.
You count too.
I also count. All right. Motion passes for agenda item number 6. Moving on to agenda item number 7, receive public comment on any topic without action. Can someone double check the hallway and make sure we don't have anybody real quick? Just want to be double sure that we don't get in any kind of open meetings if somebody's out there walking around trying to find it. We good? Okay. All right. There is no one else to make public comment, so that is closed. We will not go into executive session, so we will not need agenda item number 8 and 9. And I will move on to agenda item number 10 for adjournment. Do I have a motion?
So moved.
Second.
I have a motion by Commissioner Justin West and a second by Commissioner Justin Berry to adjourn. All in favor say aye.
Aye.
All opposed,
Aye.
same sign. Motion passes. We are adjourned. Thank you very much.